All right, we're going to continue with the class material we were talking about last time, dealing with creation of wills. Just for the context moment, we spent time talking about intestacy when you don't have a will. Our last class was spent talking about how do you create a will? What are the requirements? What are the subjective and the objective requirements for creating a will? And we talked about a lot of both. We got up to the point in the class where we were talking about, so what constitutes the will? Once you figured out what are the statutory requirements for the will, what stuff, what documents actually are read together to constitute the will? And this picks up on page 89 of the text. Your book talks about a concept called integration. So in a perfect world, you've got the will. You've got one document that's the will and describes where all the stuff's going to go. But sometimes there's other pieces of paper that may or may not be part of the will, and there may be dispute on whether those other pieces of paper are or are not part of the will. Um, the the concept of acts of independent, well, first of all, integration. Um, the importance of knowing what's in the will could be if you find a will with other pieces of paper and they're not all signed at the end. Are things drafts? Are they the actual document? Are they notes that you were trying to put together before you came up with the final document? The reason we have to know what all things integrate into the will is to answer those questions. One way that you sometimes can have some ancillary documents is if the document is included because of what's called acts of independent significance, bottom of page 90. You might say, and they give some really good examples for this. I leave a bequest of $15,000 to the winner of the Nobel Peace Prize for the year of my death, and a bequest of $15,000 to the hospital in which I die, and the residue of my property to the person whom I'm married to at my death. All of those things, you can't tell by reading those words when you prepare it who's going to get those things. But because of acts of independent significance, they're not acts that I, as a testator, can control and change later to keep changing it to whatever I want it to be. Acts of independent significance are going to decide what answers those questions. I can't control who the Nobel Peace Prize winner for the year of my death, or I can't control which hospital I'm going to die in, and change that to change who's going to get it. I'm going to be married to one person. I'm either going to be married or not at my death. I'll be married to one person. All of those things, um, can are valid, even though the specific answer to where the stuff's going to go, is sort of undeterminable at the time you execute the will. There's some elements for the doctrine to be applied, and those are it allows the doctrine allows the testator's property distribution in the will to be affected by any fact, act, or event existing or occurring outside the four corners of the will, so long as it is an otherwise objective event that occurs without regard to the testator's plan of disposition. So the answer to those questions is really outside of the testator's control, and objective facts are going to lead to the answer to those questions. Usually some action by third parties, not the testator, is going to determine where that stuff goes. Um, oh, they give you a good example of what might not be a fully objective event, and that would be proper. I leave. Um, let's see. I leave somebody the property in the drawer next to my bed, top of page 91. So you can say that in the document, and then every day you could change the property that's in the drawer next to the bed. And by doing that, you're really changing the nature of the devise. That would be something that's a little too subjective. All right, other ways that affect the actual document pages, what makes up the will itself. Um, whether, on page 91, can you include non-attested documents? We talked about all the formalities of a will, the witnesses, the notary, if you want to have it self-proved, the extra affidavit to have it self-proved. What can you add stuff later or add it from the beginning that doesn't have all those formalities with it? And the short answer is yes. You can have some ancillary documents, but there's some requirements or rules to have those things. And this all of this falls under the heading of doctrine of incorporation by reference, which is allowing a will to include a separate writing that has not been executed with the testamentary formalities. Three requirements. One, the document must be in existence at the time the will is executed. Two, the document must be sufficiently described so it can be readily identified. And three, the language of the will must show the intent to incorporate the separate document, all at the bottom of page 91. And that's the restatement requirement for those things. Most states allow you to do this. Alabama allows you to do it, um, but in states that allow you to do it, sometimes there's a limitation that you can only incorporate documents that are in existence at the time the will is executed. So the document you're trying to incorporate is in existence at the time you sign all the formalities of the will, and that you followed the three steps. One, it's in existence. Two, it's sufficiently described in the will. Um, and three, you have an intent to incorporate the second document. That third one is usually satisfied by an affirmative statement in the will saying, I hereby intend to incorporate the document into my will. Um, and the first one is satisfied if it's either in existence or it's not. And then you've got to describe it well enough for the reader to know which document you intend to incorporate. Um, the book goes on to say the UPC and some states allow you to incorporate a subsequent document or subsequently modified document. Um, and that can be helpful, usually in one area. A lot of people, one section of your will is going to address where a lot of tangible personal property go, books, clothing, furniture, jewelry, things like that. Um, and and sometimes people change their mind a good bit on those kind of things. Who's going to get my silver? Who's going to get the crystal? Who's going to get the gun collection? Who's going to get the cars? Um, and and sometimes that's not the most valuable part of the estate, but it can be a part where somebody spends a lot of time deciding where stuff goes, and the lawyer then spends a lot of time drafting around it, and it makes the document somewhat expensive. So a practical approach to that sometimes is, um, instead of doing all that in the will, Susie gets this, and John gets this, and Betty gets this, and Michael gets this, and that goes on for pages and pages and pages as you kind of walk around your house and look at stuff. Who's going to get the art, and who's going to get the jewelry, and who's going to get the crystal, and who's going to get the antiques. Sometimes what you'll do is you'll encourage a client to make a list or make a memo. A memo is really just a list. Make a list of who's going to get those things. And then the will reference the memorandum, doctrine of incorporation by reference, and say, I have prepared a memorandum which specifies where certain objects of personal property will pass, and I hereby incorporate that memorandum into my will. It allows the client to do all that work and not the lawyer, so it tends to make the will a little cheaper, the process a little more cost efficient. If you're in a state where you can have subsequent changes to that memorandum, it really can work even better. Not only is that the way you wanted to do it when you signed the will, but I've changed my mind a year later, and so I'm going to update my memo and change up who's going to get those things. And that's okay if you're in a state that allows subsequently amended memos or subsequently amended documents to be incorporated by reference. In states where that's allowed, there are a couple rules. One, the testator explicitly refers to the separate document in the will, which you're going to do anyhow. And two, the separate document disposes only of tangible property other than money, that are described with reasonable certainty. So it really is limited to stuff, um, jewelry, picture, clothing, furniture, cars, boats, things like that. It's typically not referring to sometimes what I call the real stuff. Um, you know, real estate, stocks, bonds, cash, those kind of things, where a lot of the value can be. For those types of things, you're going to have to be pretty specific in your will where that stuff goes. So they can be helpful, and in some states they can be changed later. Let's see. That's a good paragraph to spend some time on, 92, because it's a pretty practical subject matter. This does happen in wills. People do incorporate by reference lists of personal property to say where they go and what are the requirements to do that. And can you always do it? Can you always subsequently change the list after you've executed the will? When can you and when can't you? Republication by codicil. So codicil is kind of a funny word. Clients never quite know what that means, and they've never really had a reason to know what it means. But it's just an amendment to your will. Instead of an amendment, it's called a codicil. And that's how you can make modest changes to your will. At some point, you have to ask the question, when am I making so many changes by codicil that it makes sense to do a new will? And that's just a judgment call that the lawyer makes. Because every time you make a codicil, it takes, to have the full document, you have to have the original will along with the codicil and read them together. And sometimes there's two or three codicils. You have to have all those documents together, read through it. What did the first codicil change? Okay, that's changed. What did the second codicil change? Did it change something in the first codicil, or did it change something in the will? What does the third codicil do? Does it reinstate something in the second codicil? It can get difficult to read a document if you amend it too much versus just doing a whole new document and not having a codicil. Republication by codicil, though, when you do a codicil, and which has to be signed with all the formalities that the original will has to be signed with, you're effectively republishing the will with the old date and bringing it forward to the newer date of the codicil. So not only is the codicil valid and effective going forward, you've republished the old will to kind of carry forward as modified by the codicil. That can that can re what's the word I'm looking for? Can reestablish, I suppose, an incorporated document that wasn't in existence when the will was prepared, but was in existence when the codicil is prepared. So you might have a will, and you have a document that's incorporated by reference that was prepared before the will was prepared. So it's in existence at the time of execution of the will. I think the example they give you is somebody did a document that says, I leave my jewelry to the person identified on the list dated January 15, 2017 in my blue jewelry box. So that's a separate document incorporated by reference in the will. The separate document being the list typed that's dated January 15, 2017 in my blue jewelry box. It's all good because that list exists at the date you sign the will, which is January, or you signed the will on April 20th, 2017. So basically 4 months after the list in the blue jewelry box is signed. Then you go later and you make some additions to the list. You make some additions in May of 2017. Well, that's after the date of execution of the will. So in a state that doesn't recognize subsequent amendments to the document incorporated by reference, those additions don't count. They don't count as if part of the will because they were added after the will was executed. If you then amend your will later for any reason, unrelated to the jewelry or the list or anything, you amend your will by codicil later and republish it. In this example, I think they amend the will in July of 2017. Then you have a republished will and codicil as of July 2017, which is going to pick up the additions to the list that you made in May of 2017. And now those are valid because your list plus additions, both of those predate the codicil republication. So sometimes the timing of those things can make something that at first is not valid because it did not exist at the time you executed the will. It can reignite them or revive them to become valid if they're republished by codicil. So we spent a lot of time talking about formalities, witnesses, what they have to see, where they have to see it, when they have to see it, testamentary intent, how you have to sign, where you have to sign, those kind of things. Is there ever a situation where you can relax those formalities for the purpose of saving the document, saving the will, and not losing it because you missed a formality? And there's two doctrines there that might let you do that. One is called substantial compliance, page 93. The other one is called harmless error, page 96. And substantial compliance is kind of what it sounds like. You have substantially complied with the formalities. Therefore, is there any way we can save this will, even though one of the formalities is technically missing? I will tell you, it is not something that should be relied on because it's purely subjective, and who's to say when you have substantially complied or when you have simply missed the mark? And one person's substantially compliance is another person's no. You had things to do and you didn't do it. So you didn't comply, so it's not valid. You either comply or you don't. And there is no gray area. And the one example they really give you of substantial compliance where it failed was you remember we read the Burton case where the person was in the hospital and they had two documents, one signed by a witness, another one signed by a witness, and he tried to say he had two witnesses and that therefore he met the requirements of two witnesses. And the court said, no, that doesn't work. You had two separate documents. They weren't signed by counterpart. Doesn't work. You got to have two witnesses. An alternate argument they made was, this case shows up again on page 94, was that, okay, well, we substantially complied with the requirement for two witnesses. You kind of know if you're making that argument that you don't really have one. It's sort of like making the policy argument in a moot court competition. It's usually your weakest argument. And so at this point, you're kind of just throwing everything at the wall and seeing if something will stick. And that's kind of what substantial compliance is. It's like, please, court, will you please, let us win this argument. We substantially complied. And they tried arguing that with the two witnesses, and the court said no. You have two separate documents, one witness on each document, and we're not gonna extend substantial compliance to this case, which is the right decision. The other doctrine that might get you across a foot fault in compliance with the formalities is harmless error, which has actually been codified in the UPC. They give you a recitation of the statute at the bottom of page 96. Although a document or writing added upon a document was not executed in compliance with section 2502, that's the one that has the witness's testamentary intent, the document or writing is treated as if it had been executed in compliance with that section if the proponent of the document or writing establishes by clear and convincing evidence, highest level of evidence you got to show, that the decedent intended the document or writing to constitute the will, a partial or complete revocation of the will, an additional or an alteration to the will, or a partial or complete revival of the formerly revoked will. It's kind of opening the door to, again, a lot of gray. You got to have clear and convincing evidence, so you're going to have a really high burden to meet. But just the stuff you got to show by clear and convincing evidence is all pretty subjective. All the book really kind of gives you as guidance there is the larger the departure from the statutory formalities, testamentary intent, or writing to witnesses, the larger the departure from that, the less likely a court is ever going to apply this doctrine to find a valid will. And my experience has been, because the law is so clear what you have to have a valid will, you're going to be really hard pressed to succeed on either a substantial compliance or a harmless error um, type type argument. We're not going to spend time on the McCool case, but page 103, all wills will typically also have a choice of law clause to let us know, what law we need to follow in interpreting this will. And I mentioned this last class, but generally, um, as long as the will is valid in the state where you executed it, it will be valid in the state where you die, even if your laws are a little bit different. Most laws really aren't anymore. Most states have similar requirements, so that isn't as important. But it used to be that some states would have 3 witnesses, some states would have 2, so that this provision was pretty important to make sure if you died in a state where you had a different witness requirement, that your will was still going to be respected. But the law still is, if it's valid where you executed it, it's valid where you die. Your book talks about some common provisions in wills. Bottom of page 103. There's an exordium clause, and strange name, but it does some very common things. And it typically identifies who the testator is. It identifies their intent that this be their last will and testament. And it typically says, I'm revoking all prior wills executed by me, so that we know clearly this is intended to not only be the most current will, but the only valid will. I have specifically revoked everything prior to this point, which is just kind of helpful from almost an obvious and clarity standpoint. Page 104, the book talks about devises. These are gifts in the will, and there's 4 types. Good memorizing stuff here. There is a specific devise, which is kind of at the top. This is to a person of a specific thing, and it's going to have priority because you have specifically identified that thing. They're going to get that thing with priority in the document. Priority means it's going to be looked to last for things like paying the estate bills, paying the taxes, paying estate expenses. It's you specifically identified it, so it's important, and we want them to get that before other things. Next is what they call a demonstrative devise, kind of similar to specific, but it says I leave somebody an amount, and hey, why don't you satisfy it out of my bank account at XYZ Bank or my bank account at Regions? I'm not leaving the Regions account to somebody. I'm leaving an amount to be satisfied from the Regions account. And that, so what that's really telling the executor is go to the Regions account first, just try to satisfy the devise. If you can, great. If you can't, then go get it from other places, but go to the specifically identified source first, and then go try to get the balance from other places if you need to. A general devise is kind of the 3rd tier down on the rung, and that is a gift of property payable from any asset in the estate. The example they give is I hereby give a $10,000 to each of my children, and there's no direction or mandate on where that money comes from. So you can pick it from any of the assets. And then the final kind of rung on the level of gifts is the residuary, which is kind of the leftovers. I leave my residuary estate to my daughter, which basically means if there's anything left after expenses, and after giving away all the other property, the specifics, the demonstrative, the general, if there's anything left, then it goes here. And sometimes there's only residuary devises. Sometimes I leave my whole estate to my son and my daughter in equal shares. They're getting That's all residuary, but that's okay because you're not trying to carve off some special thing for someone special. Um, I might leave my house to my daughter and the balance to my daughter and my son in equal shares. That house is a specific devise which is going to take priority, and then the leftovers are the residuary devise to the son and the daughter. Read through page 106 and 107. This is a really good checklist on a will execution ceremony. It kind of ties the chapter together on making sure you've got all the documents together. You've got the document assembled. There's no stray pages in there. How you sign it, what things are important to say in there to clarify intent, and that literally is kind of how the will ceremony runs. It's 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 pretty formal. Not uncomfortably formal, but it is run pretty formal when you have a will signing to make sure it runs in a way that doesn't create doubt as to what the will is intended to mean later. And we can talk through questions on that if you have it. But that will wrap up chapter 3 on the creation of wills and the formality of wills. All right.